Okay, I'll give you a few extra minutes if you want them.
That's fine. Thank you, Your Honor. Two quick points. Both of Appellee's counsel referred to the Central Home versus Lippincott case, which of course is the 1968 case from this particular court that kind of established the installment contract idea that each one of these payments constitutes a new cause of action. In the Lippincott case, they did discuss whether an acceleration would affect the particular statute of limitations. In the Lippincott case, it was a charged-off loan, and they found that charging off the loan didn't trigger the statute of limitations. And then they talked about the acceleration and foreclosure could establish the start of the statute of limitations. We have a recent case out of the 4th District Court of Appeal. It's the Ballard County versus 8705 Hampshire Drive condo. It was decided on December 4th, 2013. I don't think it's been published yet, but in that particular case, they refer to the Central Home case and Lippincott. And in that particular case, it was undisputed that they had attempted acceleration more than 5 years prior to bringing suit. The case was ultimately dismissed, but then the 4th DCA did not cite Singleton, I'll grant, but did cite Lippincott and say we
file a notice of supplemental authority regarding that case?
Yes, I believe it's our 4th notice of supplemental authority. And so in that particular case, it was undisputed that there had already been an attempted acceleration, and yet the court went on to say this is without prejudice to bringing another case on a subsequent default. Now, going back to the court's point about why should we apply, why is it not inequitable, why should equity be applied why shouldn't it be applied? If Singleton is talking about res judicata as a legal defense, and this is statute of limitations as a legal defense, why doesn't equity apply to both? And I think that goes back to the Singleton court's analysis of the Stadler case. And the Stadler case was a 2nd DCA case, and basically...
You kind of emasculate the statute of limitations, because if we say that there are equitable arguments, for example, fairness and equity and unjust enrichment and all of that, I mean, statute of limitations is going to be so fraught and riddled with exceptions, it's basically going to become meaningless. So the judges are going to say, well, we find this is an exception to the statute of limitations, we find that's an exception to the statute of limitations, and the statute of limitations wasn't enacted for exceptions. It was enacted as a hard and fast rule to say, if you don't meet this time limit, you're out.
That's correct, but we're not necessarily eviscerating the statute of limitations. So if we say that unjust enrichment or the equities in this case are an exception to the statute of limitations, then what other exceptions are we going to apply? I don't know what other equitable arguments there might be, but because in this particular case, like I say, we've got a 30-year obligation. The borrower knew when he signed it that I've got to make these payments over the next 30 years. I can make them quicker, but I got 30 years to make these payments. So I don't see it as inequitable to come back and say, well, you prevailed on the first case for whatever reason, so we're just going to go ahead and cancel that entire 30-year obligation. They knew that they were going to be making payments over 30 years, and
You're saying the statute of limitations begins to run after the 30-year the time limit has expired?
I think that's undisputed. I think that's undisputed. If it was a 30-year obligation, it could be shorter than that. You could have a 15-year note or something along those lines.
You're saying that the date of the last payment of the note and mortgage is when the statute of limitations starts to run in all cases? Is that what you're saying?
I believe under Singleton that would be the case, yes.
Or is it 5 years as to each payment?
Well, yeah, I mean, the argument that we've made as far as equity is concerned is that if you ask for a default, something like this happens and there's a dismissal without prejudice, you could be precluded from going back to those previous defaults that you alleged.
So in this case, if you sued, if we accepted your argument and you sued tomorrow, are you saying you can sue for all the back mortgage payments or only those within the past 5 years?
No, I think equity would say it would only be the past 5 years and going forward. I don't think that the ones prior to the 5 years.
Equity, or is that application of the statute of limitations?
It's application of equity to the statute of limitations.
All right.
No. All right.
Thank you, Your Honor. We would ask that the court reverse unless there's further questions.
Thank you very much.
Thank you.